Hey YouTube family and GN subs, we are going to give you an update on Matter of Orban. This is a case where you filed your asylum before your non-immigrant status expired and whether or not you can file an adjustment of status in the United States because you are considered to have maintained lawful status. That's what we're teeing up. We got a brand new decision on policy with USCIS that I found from a decision from USCIS. That's what I'm going to discuss today. Also, USCIS's unlawful presence memo and the options you can take if you cannot adjust in the US. There's an option for you to pick up the green card at the US consulate abroad without having problems. Okay, so we're going to tee all this up for you. We're going to take this complicated subject matter, make it very simple, easy to understand. All right, a lot to get at. Let's get the update on Matter of Orban. All right, so Matter of Orban is an AAU decision. That's the Administrative Appeals Unit from 1993. What Matter of Orban says is, if you were legal in the U.S. at the time you filed your asylum, you will maintain legal status and you can adjust in the U.S. We filed many adjustments under Matter of Orban. USCIS will accept the case, issue the work permit, and the case will be adjudicated. So Matter of Orban is an AAU decision. What does that mean? That means it's not precedent. It's not binding like the BIA. The BIA is the Board of Immigration Appeals. Those decisions are binding. The AAU is only applicable to the parties that appealed in that particular case, okay? So let's talk about a BIA decision. Matter of LK decided September of 2004. Again, BIA case. What does Matter of LK say? Matter of LK says, if you were in legal status, you filed your asylum application, but the application was denied and the case was deferred to the immigration court. In that case, you cannot adjust under 245A, okay? That cuts you off. All right, now importantly, Matter of LK cites Matter of Orban and says we are not deciding that case because it's different. In Matter of Orban, there is no denial of the adjustment and referral to immigration court. So we're going to leave that to the BIA at some later date, okay? That's when you come into play with USCIS. So let's take this case that I just got January of 2024. It's a decision denying a case that was filed under Matter of Orban. And in this decision, I have the update. I have the current policy of USCIS and how they are adjudicating Matter of Orban. However, let's say I was the attorney on this case, okay, and USCIS denied my claim under Matter of Orban. I would appeal the case to the BIA. BIA has not decided Matter of Orban yet. So I can tell you what the current policy is because of this decision that I got denying an adjustment under Matter of Orban. What they're saying, there's a memo from USCIS, the Crosetti memo. What it says basically is when you have a pending asylum, it doesn't cure your unlawful stay in non-immigrant status. It's not a status issue. You do not accrue unlawful presence, but you do not have lawful status. And for 245A, you need to have lawful status in order to adjust under 245C. In essence, that's a way of USCIS saying, no, you cannot file your adjustment just because you have a pending asylum. Now, again, if I had the case, I'm going to appeal to BIA. We need the BIA to make a decision on Matter of Orban. All right, so what do I do if USCIS denies my case? So I have one option to appeal, right? Another option I have is to go to the U.S. consulate and pick up my green card. Guess what? It is clear by a USCIS memo for unlawful presence and unlawful status. If you depart the U.S. and you have a pending asylum, you do not accrue unlawful presence. It's a little complicated subject matter, but in order to be subject to the 3 and the 10-year bar, you need to have both unlawful stay. That's when you overstay your visa, right? So let's say you had a B1, B2 visa, it expired 6 months later, that's unlawful stay. Unlawful presence is when you have no status, you have no pending application. In these cases, there's a pending asylum. So there's no unlawful presence, right? And so this memo is very clear that you are not subject to 212A9, the 3 or the 10-year bar. If you depart the U.S. while your asylum is pending, there is no unlawful presence. So you're not subject to the bar. That's great news. So that's another option that I tell my clients is you can go abroad and pick up the green card without problems if you've been in the United States and you filed your asylum prior to your non-immigrant visa being expired, okay? All right, YouTube family and GN subs, thanks so much for watching GrayLaw TV. Click below, like and subscribe. Go to my playlist. Go to my frequently asked questions. Get all my content for free. It's good stuff, folks. All right, we'll see you next time.